God, as landmen, we get caught up in lawsuits. Sometimes because we're involved directly, other times because we're a supporting witness or we did some work doing something.
Litigation is not like a cold that just goes away if you try to ride it out. You got to tend to it.
It's very important for trying to avoid litigation. Having good checks and balances throughout as you go.
What's the old saying? Like, dance as if nobody's watching, but text and email as if it'll be read aloud in court one day.
Making sure that you're crossing T's, dotting I's. I think that goes a long way to protect you from any kinds of issues down the road.
We will underestimate just how expensive litigation can be.
When it hits the fan, make sure you're thinking about it and you get real deliberate about how you respond and how you handle the situation.
Land insights, market trends, industry experts. Welcome to the Land Department Podcast, the state of land and energy as we see it.
Brent, it finally happened. You had your first deposition as a landman. I don't know if we should celebrate or
what. I don't know. I was glad to get out of there, but yeah, I've weaseled my way through 24 or so years without getting caught up in one. But I did have my first deposition. After this long in the business, it's kind of cool to do something different, although it's a little nerve-wracking.
Yeah,
so it was pretty exciting. And that's where I met Lee and Brian. They were representing our client, and that we got involved in this suit. And man, I was just thinking, gosh, there's so much. I learned a lot about it. I learned a lot about depositions. And it just reminded me, God, as landmen, we get caught up in lawsuits. Sometimes because we're involved directly, other times because, we're a supporting witness or we did some work doing something. And I asked these guys, I said, God, man, would y'all be interested in doing a podcast to just talk about, how to handle yourself if you're in a lawsuit? What do you do? Give me some street smart stuff. And I could see in Lee's eyes that he's been there and done it. So fortunately he said yes, and Brian was also involved. And so Brian Wittpenn, Lee Carr, thanks for joining us, man. Welcome to the Land Department.
Yeah, thank you for having us.
Yeah, thanks for having us.
Yeah, this so I guess the way I thought I'd go about this is just, what types of things do you guys see landmen getting involved from a lawsuit standpoint? Lee, what have you seen? I understand you worked in Louisiana a big part of your career. I mean, there's been probably a lot of litigation with landmen involved. What are some of the things that you've come across in your career?
That's all different aspects. I think that one of the things we talked about was what are the ways that a landman can avoid getting into a lawsuit. Really, the only way to avoid, I think, being to just foolproof way to not get sued as a landman is to not be a landman. Outside of that, anybody can sue anybody for anything. You're susceptible to getting named in a lawsuit, whether you've done anything to warrant it or not. In fact, one situation that kind of trends off of that is where you see landman getting named is if you have, a case that's a federal action, a diversity case. You have a plaintiff's lawyer trying to stay out of federal court, and a lot of times you'll see them name a lot of different contractors, landmen, everybody in, because the bar is really low as far as stating a claim to destroy diversity. And I say low with respect to actually being successful on the claim.
Yeah.
So it's not exceedingly difficult to articulate some sort of claim against the landman that's just not completely frivolous, that brings them in, even if they're, they got E&O insurance or whatever. It's kind of like if you have a land broker, the land broker, is working for a client, and then the land broker, they hire consultants, and so you have each guy that works for the land broker is a 1099. They're their own company. They're, Lee Carr Landman LLC. And so you end up to get, the broker, then Lee Carr and Landman LLC, and then Lee Carr himself individually, because they're trying to get in as many different parties as possible to find that magic diversity destroying.
Yeah. So, I mean, you do have multiple degrees of separation, and, you have as a field landman, you got your client, your company guys, and then us. I mean, typically when there's title disputes, we've gotten, our work product involved in a number of different lawsuits, right? Well, here's the Dudley report, and here's the title opinion that, came from X law firm. We say that our title shows X, your title shows Y. We've gotten caught up in that type of stuff, the whole title dispute thing. One of the things that I think happens a lot at the company level is like contract. What do you guys tend to see on that? Is that something that typically will go all the way to court, or is it, suits get filed and then it settles? Like, what do you guys tend to see?
Things can always go sideways, but typically I think, or the contract disputes that I've been involved with have all been sort of not oil and gas related, unfortunately. But yeah, I mean, you do everything to try to come and have a meeting of the minds. And so when that falls apart, and it sometimes does, as we know, that's just the next step. The filing of the suit.
That's the next step.
Yeah. I mean, almost all lawsuits get settled. It's very rare that something actually goes to trial. So that's always something that we're looking for, is some kind of way of, ending the dispute in a way that, the parties can walk away. So
Do you tend to see, obviously things get settled a lot, and I would agree with that just from what I've observed. Do you tend to see like you got to fight it out for a while and then you ultimately settle? Where you would have people getting deposed, or, subpoenas getting served, and then you ultimately it's just trying to get to the settlement point. Does it typically go that far? Or?
Yeah, I mean, for the one that we just had your deposition for, we did 3 depositions, and we have 3 different MSJs on file. The other side's filed some. It's called motion practice. We got to go out to the cities, the county where the property is located, and actually argue in front of the judge. But, always we're hearing, that there's back channel communication happening between plaintiff and defendant, and they're trying to work it out too, right? The lawsuit's just a tool to try to gain some kind of advantage,
Yeah.
Yeah. And a lot of times, people get 2 or 3 cycles deep into litigation bills and they get less mad real fast. I mean, that's and I think that a lot of people underestimate just how expensive litigation, can be. I mean, just a simple, Brian and I were talking about this, just a simple deposition, it's going to involve, I don't know how long yours was. Probably I would say just 2 or 3 hours, given the transcript. But if that's, let's just say it's a 3-hour deposition and you've got 3 lawyers sitting in there, the court reporter, that you're clicking off probably a $8,000 to $10,000 bill leaving there, and then the transcript's got to be $800 to $1,000, and then you got to summarize it. That's just one deposition of the land broker in the royalty dispute.
Yeah. I mean, it was my deal. It was a better part of a day. I mean, I think I got there at 8:30 or 9, and I didn't leave till 3, and the breaks, and the whole time there were 3 attorneys. To your point, Lee, I mean, there's 3 attorneys in the room, that were on our side, the 2 court reporters, a recorder, transcripts, all that stuff. I can't imagine the cost there. It's kind of one of those things.
Go ahead.
Yeah, I think the wise thing is to think through, all right, if I'm going to get into this, how much am I willing to spend? Is there enough meat on the bone for it to be worth it? And yeah, you're right. After a couple cycles, it probably gets less and less appealing to see it through.
You think about it, your deposition was that day alone was equivalent of a pretty well equipped John boat. Off the school. It's there.
It was like 3 of my first John boats, at least.
Well, yeah, that's true. I'm talking about the 2025 John boats. Yeah.
Not the one that you cobbled together and you bought, Frankenstein.
Literally, that was my first one. I took it off of the trash pile, and for some JP Weld and
oh man, we can do a whole nother podcast on crappy Landman John boats. I think that would be more relatable. For sure.
Absolutely.
But so let's just kind of talk through. So I mean, everybody obviously wants to avoid litigation, right? And it's the worst case scenario. What are just some of the basic fundamental things, Lee, on just how to avoid litigation? Just basic behaviors as landmen. I mean, landmen do a lot of B2B work, business to business discussions, contract negotiations. If you're a field landman, you're dealing with the public, you're dealing with landowners, you're dealing with sophisticated land and mineral owners. Just what are some of the just kind of basic things you need to do to avoid getting into litigation?
Well, I think sometimes, especially if you're in like lease negotiation or even right of way negotiation, is making sure where you're at as far as an agent position. A lot of times land brokers get in trouble when they try to be the middleman, buying their own name and flip, which that's fine. That's a business risk that they take. But another situation where you have is especially in Louisiana, when you have an undisclosed agent and an undisclosed agency situation where you're on behalf of a principal that doesn't disclose his agency or the actual principal, he's on the hook for that until that principal becomes notified. So that's one way that that you can get pulled into a lawsuit or take steps to avoid it, is make sure that you're disclosing your status as an agent. And if you're not, for a business reason, at least understand the risk that becomes along with that and how to mitigate that. And one way to mitigate it is to have yourself be named as an additional insured on the E&O for the agent. Another way to mitigate that is to disclose the agency at the proper time. When you get past the letter of intent, you get to the binding reps and warranty stages.
Let's talk about what that looks like in the real world, Lee. So say I'm a field landman, and I've been hired by a company to go out and negotiate leases with a mineral owner. And I'm doing it, my client wants to be stealth, right? They don't want the public knowing that, XYZ oil is active in this area. What's required of the landman to properly give that notice to the owner to protect them from the situation you were explaining?
Well, they can disclose their agency without necessarily disclosing the principal. That modifies their exposure a little bit. I need to go back and look at that.
So what's the agency mean? So it's like, I'm Brent Broussard, landman for Dudley Land Company, leasing on behalf of a client of ours in the oil and gas business that's looking to put a project together. Is that sufficient notice, or is that enough or not enough?
So that would be a situation of a disclosed agency and an undisclosed agent. I think in both cases, the agent can be held liable, and the difference is if the principal is notified, or if the person is made aware of who the principal's identity. Then if you have a disclosed agency, undisclosed agent, then I think that shifts the liability, whereas I'm not sure that it does if you have both an undisclosed agency and an undisclosed principal.
Okay.
So in that situation, I guess what you've got to do if you are, let's say you're actually taking the name, taking the lease in the name of, say Dudley Leasing Company, and then of course with the intention of assigning it to, XYZ Oil Company. I don't know that avoiding litigation, like I said, the only way to really avoid it is to not be a landman, but to mitigate that risk is you've got pretty healthy identity provisions in that assignment to XYZ Oil Company. And realistically, given the leverage that they have, those are something that would probably need to be worked out ahead of time.
Yeah. Okay. So it really just boils down to clear communication, have good documentation, make sure that your assignments, out of whatever your entity into the eventual purchaser, clean and well reviewed and documented by counsel, and so on and so forth. I guess that just boils down to not doing shoddy land work. Don't be shady. Be on the up and up. Don't lie to the public. Don't misrepresent who you're representing. One of the things we see a lot, it kind of goes down to ethics. Really, don't be snaky and you won't get sued, kind of thing.
Right.
Well, so that was actually not to dominate the response here, but that was one of the next things that we were going to bring up is, Brian and I talked about, don't be shady, don't be crooked, I had one case where the landman was claiming, or the plaintiff was claiming that the right-of-way agreement had greater rights than it did. The substance of the agreement was not I guess the focus, what it meant, not really the formation or the execution, but they were deposing the landowner who granted that pipeline right away. And we were talking about how, what was meeting of the minds type thing, who was there, what we are talking about, what was discussed. And this was a right-of-way agreement that was executed. Being from Louisiana, you probably know, in notarial or authentic form. It was before a notary and two witnesses, which is a little bit different than the subscribing witness situation here in Texas. It's got to be executed in front of the notary, in front of the two witnesses, all at the same time. This one was authenticated or in authentic form with the notary and two witnesses. And that's relevant because it establishes the authenticity if you ever have to go to court over it. Maybe not admissibility, but you don't have to have somebody come in and attest so much as this document is this. I recognize these signatures because it's authenticated, because it's done in front of a notary and two witnesses. This one was done in front of a notary and two witnesses. So I asked the guy, does he remember the witness or the notary and all that? He said, no. He said, we signed it in the booth at the truck stop. It was just me and the broker. And so what happened is him and the brokers, he signed it. The guy takes the agreement back to his office, notarizes it, gets two witnesses to sign off on it, and it rolls with a fake authentic form. It really is considered filing a false record. The judge was not real receptive to that bit of information. We ended up getting their preliminary injunction denied and zero. They didn't do it themselves. That wasn't even the focus of the lawsuit. They could have done it without doing all that, but that garnered such significant bad will. So don't be shady. I guess that's a long way of saying don't
take shortcut. I mean, you see that in Louisiana a lot when you do have to have those witnesses. It can be inconvenient to do that.
I've made one re-sign before in front of me.
Yeah.
They signed it, brought it in. I was like, no, you're going to have to sign it in front of me. So
well, especially attorneys in Louisiana carry a heavy burden as far as it's not easy to go get to be a notary public in Louisiana, right? Obviously as an attorney, you have statewide authority to notarize, but outside of that, it has to be someone from within the parish. And, there's heavy testing to be a notary. It's not just like in Texas where you apply for it and send in a check. But I guess that all goes back to make sure you're following the procedures, make sure you understand in the state, as a layman, the state you're working, what those notarial requirements are, and follow them to the T. We always did subscribing witness acknowledgments in Louisiana, and those were sufficient, right? And everything was documented. Our landman would be the subscribing witness, and then they would bring that to notary publics. We provide proof of identity and all that stuff to clear it up and try to be on the up and up, and do things the right way. So that's certainly it.
Well, before we leave this topic, there's another thing I think that is very important for trying to avoid litigation. And I think that's about process. And so having good checks and balances throughout as you go, not only with your own work product, but your office, writ large sort of thing. Even as attorneys, we do this. An examining attorney might draft a title opinion after reviewing instruments, but then it will go into review. And another attorney will then look at their flow chart, look at the comments that are being drafted, see that there's agreement with the reviewer, maybe even have a meeting where you discuss the various issues. But having those kinds of systems in place where you're making sure that you're crossing T's, dotting I's, I think that goes a long way to protect you from any kinds of issues down the road. So,
yeah, I think, to expand on that with work product that comes from brokers, or from a field landman to either an in-house landman or a law firm for a title opinion review, is just qualify what you did, right? Don't turn in a report and say this is a full ownership report when you only did a 30-year cursory. Call it a cursory, right? Don't send in a run sheet or an abstract and have limited your research to 1930 and don't note it. Disclose. You want to be clear about, where did you do your examination? Did I do this from online records? Was I in the courthouse? What indices did I check? What date ranges did I run that from? Who did the work? What the landman that did the work? You want to reference all that. And that's just really qualifying the product that you're turning in. Right. People make decisions after, a field landman does their work. An in-house guy's going to get a report, and he may work through, negotiating a whole deal from that work product. And if it was cursory in nature, then you're just putting your client in a bad position, and potentially, lead to problems on down the road. So I think you're absolutely right about just qualifying what you do and making sure you've got a good process to clear that.
We had a case, I actually told Brian about this one too, where the landman's notes and his process actually were extremely instrumental. This was back in the Haynesville Shale heyday, when bonuses were just absurd in Northwest Louisiana, and royalties were very high, and our client got sued by some landowners or some mineral lessors, that because their mineral lease was your standard 1/8 royalty, and they had basically just granted the lease right before the boom discovery. Yeah. And so they filed suit, and their claim was that the company had taken the front page of the lease and replaced it with one with a lower royalty. And that's why we were able to stick them with a 1/8 royalty whenever the rest of the world's getting, 33% at times up there. And they deposed the landman. I met with him. They deposed him, and maybe we didn't depose him. Maybe I just met with him. Anyway, it come out. He told me that, he said, I remember at that point when we were doing those leases, we were doing them on one page, front and back, save paper. So I ended up, because he knew that, he says, I would have never went to check. I went to the DeSoto Parish Courthouse, went down in the basement, not even the regular records, had them pull me the actual copies of the actual lease, showed up one page front back. We videoed it, them pulling it out. And of course, at the appropriate time, I let the opposing counsel know about the video. The case went away. That was all because the landman had notes in a process and had gone through those steps. So it was helpful.
Yeah. That's kind of a unique thing in Louisiana, is that the originals live at the courthouse. That doesn't happen in every state. So just a little bit of knowledge about how, those sneaky things that you can't pull a one over on somebody because the original's there. I had another scenario. I'd love to talk about offers and counter offers, and it just kind of plays off of the Louisiana and the Haynesville and these peak times, and it really applies to any state, but we can speak to Louisiana. But scenario where oftentimes landmen are jumping into a new area, and we're kind of seeing that right now with a lot of greenfield leasing in parts of the country, and you're negotiating deals, and terms get offered, and the price of poker seems like it's going up week over week until it settles out to whatever the number is going to be that people are willing to pay. But we've had situations where you make an offer and then there's a counter offer, and then maybe you step out of the deal. The client says, no, I'm no longer interested in this area. Well, we got caught into a lawsuit because of a group of landowners put out a big package. We bid on the package, X amount per acre, and it was an absurd amount of money. And then we decided to, the rock was bad. The client wanted to back out, and they actually went through and went through an offer and counter offer process because they marked up the addendum. Just in general, have you guys run into anything? And ultimately, we were able to get out of the deal because there was a when they marked up the lease and sent it back to us, that was considered a counteroffer and allowed us to get out of the deal. Have you guys see anything like that? Is that common anymore? It was a big deal then because it was a lot of money to lose. But what y'all's experience been in that? Have you run across that any?
Yeah, I mean, anytime that I'm negotiating, settlement, as we're making those counter offers, there's a clear understanding that, that acts as a rejection of the previous offer. So that offer's off the table now. I deal with that in my practice. Yeah.
I've seen it quite a bit too, and that's kind of the way I've always stressed it to my clients, is that a counter offer is a rejection of the offer, and then it is an offer. Essentially, if you make an offer, and I've seen it both ways, where the guy's like, "Hey, we made that offer," did they still come back and take that? I said, "Well, no, they countered, so you're off the hook if you don't want to do that," or that's it. Pretty much any substantive modification is a rejection handled.
Yeah. What about, I see kind of in that vein of negotiations, we always have our landmen put basically a termination of the offer. You send a written offer to someone, you don't want it to be open-ended. So I always tell my people to avoid any issue, put a termination date, or say this offer is good for 30 days or 25 days. Or if you want to back out before then, send notice. Have you run into situations, or you see any lawsuits or got involved with things where an offer was extended without a termination and it was just open-ended for a period of time? What guidance would you give to landmen on how to best handle that?
I mean, I'm not to do that.
Yeah.
Put it down.
Absolutely.
And I can't say that of all the offers I've made, I've never set one and not give it a drop dead. Typically, I know the rule in Louisiana, probably in Texas, if you make an offer, then the rescission of the offer if it doesn't have a drop dead, is obviously possible at any time, but it has to be made in the same form that the offer was made. If if it was in writing, you can't, it needs to be a rescission in writing. It was smoke signals but
Okay.
it's got to be the same form of obviously that's something to avoid. I don't think I've ever seen a situation where it's come back and bit either side, but I have at some point, gone back and looked and made sure that my email had the termination date. And I have sent emails rescinding offers just to be sure.
Yeah. So, all right, we talked about things that, can get you in trouble or keep you out of trouble. But what if you turn around and come up and all right, I'm in it. I've been served, I've been sued, whatever the case might be. What are some of the kind of tips that you guys would give? Either stop communicating in writing, don't talk at all. Like, what kind of guidance, if I was, telling you, hey, I called you guys and I'm subject to something, I got this nasty gram letter and they're going to sue me. What are just some general, like, street smart, tips and advice for a landman on how to handle communication with the other party, once you're in it?
Yeah. Well, absolutely don't ignore it, because that's a problem that we see a lot, where somebody comes to us, right when they need to be filing an answer. Dealing, a lot of times people just think, if I just bury my head in the sand, it'll go away. But I think immediately addressing the issue, hiring counsel, that's going to be, and as soon as that's going to be the first thing that I would advise.
Yeah, absolutely. Especially if if it's a landman that works with a broker or part of a larger organization, you're going to want to probably put your malpractice or your E&O insurance on notice, because a lot of times the way the policies are written, they'll provide a defense to the claim if it seems to be something that's covered by insurance to that extent. If it's not something that's covered, to that extent, then, then maybe you're looking at, is there an indemnity provisions of their agreements or the third party claims? If you're getting sued because you're an easy target and somebody else really committed the negligence, then you're either going to want to say, hey, I'm making an indemnity demand because of, this MSA, or I'm filing a third party claim because you're liable to me if I'm liable to them. And if you ignore it, then you lose, the clock ticks on a lot of that stuff, and you lose the ability to protect yourself. So yeah, what Brian said was perfect. The best thing is don't ignore it. Litigation is it's not like a cold that just goes away if you try to ride it out, and you've got to tend to it. In fact, I wasn't too long ago last year where somebody came to our office when I was still in Louisiana about a litigation, and they presented us with a default judgment that we had to try to fix. And I was like, well, man, you're pushing a rock up a hill because a landman got it, sat on it, didn't send it, to the proper channels, and there they are.
Right. Yeah. And then once you've hired counsel, once you are represented by counsel, all communication really should go through your counsel. That's the best practices.
So big no is to obviously wait. You don't want to wait because there's a lot of work that needs to be done. There's action that could be taken to rectify it or fix the situation. But once you've done that, you've engaged counsel, you don't want to be communicating with the party that is across the table without your counsel being involved or know what's going on, or is it just a general word of advice? Don't talk to them at all. Have your counsel reach out to them.
I mean, there are situations where back channel communication can take place. That in fact happens quite a bit, but you have to be smart about it. In general, you need to recognize that it's an adversarial process, that the other side has sued you. And so they believe that you are in the wrong and they want some kind of compensation for that. So directing communication through counsel is in general the best practices. Yeah.
Another good reason to avoid that direct conversation is, in a courtroom or in a trial, you have hearsay, which is inadmissible. It's an out of court statement or declaration made by the witness outside of court. However, there are a lot of exceptions to that, and one of the exceptions is an opponent party admission. In other words, I can testify if you sued me and we're going against each other in court. I can testify as to what you've told me, and it's an exception to hearsay because it's an adverse party admission. So, what your representations and communications here in that process can be used against you, unless they are settlement conversations. Typically, settlement discussions are protected and inadmissible. But then again, you're creating a blurry line of, a lot of times where we're talking settlement negotiations or, what it's just like I said, it gets messy. So that's one thing to be wary of.
So if you are going to potentially reach out to whoever your adversary is and try to talk settlement and say, hey, what can we do to work this out? You want to be clear when you start that conversation. Like, hey, I want to talk about how we can work this out. How can we settle this? Be clear with that, and then be going into that conversation. So at least you're somewhat protected from anything you say during that conversation being used against you.
Correct.
Okay. Gotcha. I think that's one of the things over the years, and fortunately, like I mentioned, only been deposed once. But we get caught up in things all the time, and negotiations with attorneys and company to company stuff. And I think day-to-day correspondence is one thing, but correspondence and how you talk and what you say and what comes out of your mouth and the words you use are a big deal when you're in a contentious situation, right? So general rule of thumb that I always use is recognize that you're getting into something. Be cognizant of what you say and how you say it. Be cognizant of how you communicate, what you put in writing, what notes you take, what notes you don't take. right? Are also important. Because all that, when it comes down to it, when you get subpoenaed, you have to give everything. So maybe I always thought it was cool. Like, can you guys strategically, when you're subpoenaing someone, explain to the audience, like, if you're subpoenaed, what do you really have to give up, and how far reaching can it be? Talk about subpoenas, Brian. What's generally involved in the subpoena process? Like, how far reaching can it be if you're issued a subpoena?
Yeah, I mean, anything that's relevant is going to be within the scope of what they can ask for. You can really ask for quite a bit in the discovery process. We do requests for disclosure, requests for admission, and then ask for production. Now, and Lee can talk about this. We had another broker recently that was subpoenaed for production of documents, duces tectum, and it was about the scope of employment of one of their employees who was a party to a suit. And so, really, he can talk about the scope of what was provided in that, but they weren't even a party to the lawsuit, right? And so they were just being asked to, or really demanded to through the power of the court, to produce these things into this lawsuit. So
yeah, and really, I guess the good thing to realize if you get a subpoena is that subpoenas are directed to third parties. So if you're getting subpoenaed, that means you haven't been sued,
right?
At least not yet.
Okay, all right, that's a good point.
Yes, so subpoenas are typically directed to third parties, and there are limitations. I know, like in federal court, Rule 45 kind of breaks out what you can subpoena for and what the limitations are. There's a subpoena to attend a deposition. There's a subpoena to produce documents. Then you can issue a subpoena to appear in court, and they each have different limitations. There's a dispute right now where like you can subpoena a Rule 45 or a corporate deposition but you can't subpoena. So you can subpoena a company to give a deposition under Rule 45 federal rules. It's considerably less clear and whether you can subpoena a company to appear and testify in court, because you can only subpoena a person. There's case law that suggests that you can't. It's at least that I have seen, it's not been persuasive or has not been binding or overwhelming, compelling enough that you can still make an argument that you can subpoena them. But then you have limits, of course, on, I think there's 100-mile limit where you can have somebody come testify. You can have, you've got to be within the jurisdictional area of the court, which is part of the reason why I think there's an argument that you can subpoena a company to testify in the court, because what prevents a company, if you subpoena them, say, hey, and they designate a corporate representative that is across the country, and then that corporate representative shows up for the deposition, but they're outside of the jurisdictional limits when it comes to testify at trial, so that's a wrinkle with that subpoena. But typically, like for a trial, a hearing, a deposition, you can command them to appear within 100 miles of where the person resides. In fact, when I was in Louisiana, we had this issue in Texas. The third party that they wanted to subpoena was based in, I think, College Station, and they issued a subpoena for Louisiana. There's like, no, we're not doing that. We're not coming. This was a state court subpoena issued through letter of rogatory in Texas, but they were outside of the jurisdiction. So we ended up having to take the deposition of one of the play people where the company existed, and then another person who worked remote. To our other point, we had to go to Mount Pleasant, Texas, to take their deposition because it was with we had to go to them.
Yeah. So some of the things like when we've been, when I've been issued subpoenas for various things over the years, your emails, you're going to have to give all your emails. any and all email that references a discussion or a particular tract of land that's subject to the litigation, all that is out there. Everything you say in those emails is out there. It's gonna go, and you can't hide it. You can't not submit it. We've been asked to submit reports, field reports. What's a field ownership report? Give me your run sheet. Give me any digital file that you received on this project. I need access to any of your correspondence back and forth with your landman while doing the work. Correspondence back and forth with your client, that you're working with, whether you're a company guy and you're talking with your landman in the field, negotiating an agreement, you have to have all that back and forth, and you're going to be required to submit all that. So that's kind of goes back to the importance of what you put in writing.
Yeah.
Could potentially be put in a transcript. It's going to be there in a file. And
to go back to that last part about ability or the reach of the subpoena, one thing to be very careful and make sure that you're reaching out to counsel if you're served a subpoena is that a lot of these landmen operate under an MSA with a confidentiality agreement in it that requires or makes an exception if you are responding to a court order. But that exception doesn't apply if the subpoena is not valid because you're outside the jurisdictional limits. So make sure you don't respond to the subpoena that you didn't have to respond to and then accidentally breach your MSA with your vendor.
Then you just cause all kinds of problems. So, I mean, that kind of goes back to don't avoid it. Whether you're the company side or the field side or an independent or whatever, when we get involved in this, you want to reach out to your client, inform them that, hey, I've been served a subpoena for this. You're a named party in this. That's often how it works out, right? It's two companies fighting it out, and you're a landman and you get brought into it, or you're a landman for company A, and you're duking it out with company B, and you're going to be involved. So be careful about what you're saying, how you're saying it. Have your email correspondence be clear, to the point, professional, and business-like.
Right.
Right. You don't want to put in writing, and I hate this son of a B, and I want to screw this sucker.
You may want to put it in writing.
Yeah.
You can save that for beers, at the end of the day, between your buddies or whatever. But be cognizant of those things. Your reports will be, all your work product, especially from the field side, is subject to being submitted and reviewed. We had the recent thing we did with Brian, where I had to submit correspondence and work product and emails and tracking reports and cloud file storage of everything we did on a project 4 years ago or 3 years ago. I think that the work actually happened. So maybe that's a great question. So file retention. So if I have a file retention policy in my company that says after 2 years or 3 years, I delete anything that's in my files, right? Or I archive and delete my emails. I archive and delete my file storage, after X amount of years. Is there protections there if you have a documented policy in place that says this is my file retention policy? I cannot provide you with that report or with that email correspondence because I've archived it subject to my policy. Are you protected there? Or is that kind of a general good practice to do that? Or would you recommend you hold things for longer? Or is there a period of time that you recommend maintaining files? Or what are the protections and how do you navigate that?
One of the things is to make sure that the policy is well documented and everybody knows about it, so that when you have to go out and say, hey, no, I don't have that because we have a 6-month, 9-month, 12-month rolling window document retention on emails, that it was like, yeah, prove it. You make sure it's documented somewhere, not just in an email from HR to the council saying, yeah, that's our document retention policy. It needs to be somewhere that you can show concrete evidence that this was our policy before you sued us. We didn't come up with a 9-month retention policy when we got served with the lawsuit. Because that brings up another issue of spoliation. I know that's a tort in Louisiana and also in Texas. Is if you destroy the evidence in a manner that spoils the substance of a lawsuit, then you're creating yourself liability equal to what would have been the liability had the evidence not been spoiled. I'm sure that's how it is also here, Brian.
Yeah, that's correct. Spoilage. It's pretty clear. I mean, and even then, you know, with the way that metadata and all this kind of, you think it's deleted, and there's often a way that somebody can recover it, and it's just a bad look, right? Especially if you do it on the eve of being sued, you know, where you know that you're about to be sued. You know, I thought about something from your deposition, actually, and having things in writing. There was a point when opposing counsel was sort of calling into question the landman who had done some work, right? Like whether or not that person was competent. And in an email, you may recall that opposing counsel had handed you that email without realizing that in there was a statement that landman was a great landman, and we should definitely try to keep this employee or contractor. Having those kinds of things, you know, in writing. Hey, this is a great employee. You know, maybe not.
Yeah, it can
a
go.
lot.
It can go for you. Or
Yeah,
against
actually,
you.
it can go for you too, right?
It just goes to the importance of, again, what you say in your emails is never, you never know when it's going to come back. In our case, to your point, they were questioning the competency or the skill or ability of that landman, and we'd gone what felt like for an hour, you know, back and forth on that, and ultimately they handed me an email about something, and at that point I was a little perturbed because it kept going, and I just saw, hey, you should, you know, these are people who've done a great job on this project, and that landman was named. I think, you know, she's a keeper kind of deal.
Right.
And so I made it a point to note that and have it on the transcript. And at that point, maybe it worked against the opposing counsel
Right.
and it was just a completely unsolicited thing, but it's on the record now and it's there.
Yeah, and I mean, I know that I've experienced this both in receiving discovery and in having to review and then send out things for my client. We've all seen those off-color jokes or the bad looks, you know. So I think you had said, Brent, that you should always, in those kinds of communications, just realize that someday conduct yourself in a way that you would be comfortable in presenting that to a court at some point, right?
Yeah.
What's the old saying? Like, dance as if nobody's watching, but text and email as if it'll be read aloud in court one day.
Right.
That's it. It's well, guys, this good takeaway. I mean, it's a complicated thing. There's a whole lot of circumstance and nuance to any time you're involved, and suit or you get drug into something. It's the big takeaway is if you get involved in something or you're in a contentious situation or even a day-to-day job, conduct yourself professionally. Understand that what you put in writing and what you say can come back to bite you. Understand if you're working in a new state or you're working in a new area, understand what's required of you with your documentation and you know, execution of documents, especially as landmen. And you know, get counsel. If you're getting brought into something, don't hide it, don't delay. Get it in front of your client, get in, you know, advise everybody who's involved, get with counsel, and really think about your responses from that point forward. How you communicate, what you say, what you do. I think that that's the big takeaway. Hopefully, you know, most landmen are like me. You don't get sucked into anything for a long time, but it's inevitable. So we do a lot. We skirt the limit there on the work that we do as landmen and as business professionals with the transactions and all that we do. There's always money being exchanged. So when you've got that, you've got potential for something to go awry. So I think generally, if you live by that, you're going to be in good shape and you can go through this deal and be a landman and conduct your business without problem. But when it hits the fan, make sure you're thinking about it and you get real deliberate about how you respond and how you handle the situation. And call these guys up. They'll help you out.
Yeah.
But Lee and Brian, thank you guys. Appreciate you kind of walking through some of this stuff. It's complicated. how can people get in touch with y'all if they need some support or need some help?
Well, we have a website.
You can go to kmd.com. Was it kmdlaw.com? I gotta look that up.
I think it's KMB.law.
.law. Yeah.
.law.
KMD.law.
Yeah, we'll put y'all's contact information in the notes and stuff from the show. Yeah, appreciate it, guys. Thanks for coming on and walking through some of this nastiness with us.
Yeah, like I said, if they need to, they just tell them to call you and you guilt. It's all right.
I know. Yeah, I know some guys. That'll help you out. Well, y'all are great and supportive of us, and I wanted to kind of dive into a difficult conversation. So thanks for walking through this a little bit with me, and hopefully I don't have to send many folks to you, but if I do, I know they'll be in good hands.
Appreciate it.
Absolutely.
Thank you.
Thank you.
Enjoyed today's topic? Follow us on Spotify, Apple Podcasts, and YouTube. Learn more at dudley-land.com. See you next episode.